Good afternoon to all. Welcome to the Committee for Justice's panel on the Education Department's new Title IX rules for sexual assault and harassment that were just released last week. They're intended to ensure that every accusation is taken seriously, while at the same time guaranteeing due process and a presumption of innocence for the accused. Now, many say that due process was lacking at schools since the Obama administration issued Title IX guidance in 2011. Other people, most notably Joe Biden, have been very critical of these new regs and have said they will make it harder for accusers to obtain justice. The panelists, all of whom are leading Title IX experts, will give you their opinion on how these new rules will affect things. I'm Kurt Levy. I'm president of the Committee for Justice, and I'll be moderating. So let me introduce the speakers in the order they'll be speaking. Stuart Taylor, he's an author and freelance writer who focuses on legal and policy issues. He's often been called one of the nation's best legal journalists, in part because he's known for challenging both the liberal and conservative conventional wisdom. He's co-authored books on today's subject, on affirmative action, on the Duke lacrosse rape case or fraud, as it turned out to be. He graduated from Princeton undergrad, then graduated from Harvard Law School. He was a reporter for the New York Times in the 80s, covering legal affairs, and then he was their Supreme Court reporter. Before that, he practiced law right out of law school with Wilmer, Cutler, and Pickering. He's also taught at Stanford Law School in 2011 and 2012, and he still practices law upon occasion. Our second speaker will be Jennifer Braceras. She's the director of the Independent Women's Law Center at the Independent Women's Forum. The political columnist, also former commissioner on the U.S. Commission on Civil Rights. She writes about issues that are at the intersection of law, politics, and culture for the Boston Globe, Wall Street Journal, and a bunch of other publications. She's taught at both Boston College Law School and Suffolk University Law School. She was a trustee of the University of Massachusetts. Like Stuart, she's a Harvard Law School grad. After law school, she clerked for two federal judges, one on the U.S. District Court in Massachusetts and one on the Second Circuit U.S. Court of Appeals. And then last but not least is Nicole Neily. She's president of Speech First. That's a nationwide organization that defends students' free speech rights on campus, something that's been very much needed in recent years. And they do that through a variety of methods, but including lawsuits against University of Michigan, University of Texas, and other universities. Prior to launching Speech First, Nicole worked at several important nonprofits like the Independent Women's Forum, where Jennifer is, Cato Institute, and the Franklin Center for Government and Public Integrity. She has a bachelor's from University of Illinois and a master's of public policy from Pepperdine, where she's on the board of visitors. And while at the University of Illinois, she was a vice president of its Pan-Hellenic Council, which at the time was the largest Greek system in the country. Let me ask Stuart to start it off.
Thanks very much for letting me start it off, Kurt. I'll begin by summarizing how very badly the current campus regime across the country for sexual assault and harassment trashes due process, trashes due speech, free speech, and how it systematically violates the Title IX rights of young men, college males, by discriminating systematically against accused students, almost all of whom are male. I'll also discuss the training materials used by campuses to indoctrinate their sex bureaucrats. The word indoctrinate is a heavy word, but I think if you were to read these training rules, you would see the logic of it, into presuming guilt, really. I'll leave it to Jennifer and Nicole to explain the new Title IX rules adopted by the administration last Wednesday and its strengths and weaknesses. Except to say of the new rules, one of the greatest strengths is its requirement that these training materials, until now treated by campuses as closely guarded secrets, be made public on each campus's website. This will make a huge difference. If the current training materials at most schools were made public, I'm confident most and perhaps all of them would be instantly exposed as manifestly violating the new federal rule. Of course, the background is that until the last decades of the 20th century, universities did far too little to protect women from sexual misconduct, and many women were badly victimized. What we're seeing since then is a huge overreaction to that problem, which was a serious problem. But the campus pendulum was swinging wildly toward anti-male ideology well before the Obama administration arrived in 2011, and therefore essentially mandated the presuming the guilt of accused males, with Vice President Joe Biden leading the charge. Schools that did not comply with the Obama mandates were threatened with deprivation of their federal money and with being held up by the government and the media as soft on rape. The procedural regime decreed by the Obama Biden Education Department's Office for Civil Rights since the infamous 2011 Dear Colleague letter has led to expulsion or other harsh discipline of countless hundreds of students by denying them a fair opportunity to defend themselves. This policy was unlawful because neither justified by anything in Title IX nor adopted through the kind of notice and comment rulemaking required by the Administrative Procedure Act. It included a virtual ban on cross-examination of accusers, a mandate that universities find accused students guilty if they found guilt by a preponderance of the evidence, which in many cases was almost as consistent with innocence or even more inconsistent with innocence as with guilt. This despite the fact that many universities require clear and convincing evidence of guilt to discipline similarly accused faculty members at many or most campuses. The Dear Colleague letter also mandated a speed up in investigations, making it harder for accused to prepare a defense, and more. The virtual federal ban on meaningful cross-examination of accusers has been an especially crippling blow to fairness because it has deprived accused students of what the Supreme Court has called, quote, beyond any doubt, the greatest legal engine ever invented for the discovery of truth, end quote, especially in sexual behavior cases in which he said, she said is often the bulk of the evidence. Worse, the Obama administration put intense pressure on schools to show they are getting tough on sexual assault and to instigate a so-called single investigator model that makes one person appointed by the school's Title IX coordinator into detective, judge, and jury. All of these federal mandates made guilty findings more likely. And universities have been so ideologically predisposed to presume guilt that they have pushed even harder for pro-accuser policies than the Obama decrees required. Typically, accused students face Title IX coordinators, investigators, and decision makers who are neither impartial nor unbiased nor free of conflicts of interest, but rather ideologically disposed and secretly trained to presume guilt and ignore exculpatory evidence. The training materials typically indoctrinate campus administrators and adjudicators to believe that almost all accused students are guilty and almost all accusers are victims. Campuses use extremely broad and vague definitions of sexual harassment and assault, such as presuming that if the woman had been even moderately under the influence of alcohol, she lacked capacity to consent to sex and was thus raped or assaulted, depending on the details. Indeed, in the words of Harvard Law professors Jacob Gerson and Jeannie Sue Gerson, quote, the concept of sexual misconduct has grown to include most voluntary and willing sexual conduct. And they write along an article that shows that's not hyperbolic. The rules deny, or the campus rules in most places, deny accused students timely access to the specific allegations and evidence to be used against them, and even to exculpatory evidence in the university's hands. They limit their ability to call witnesses to testify. As I've mentioned, they and their advocates are not allowed to cross-examine accusers or other witnesses. Now, the evidence we've seen in case after case suggests that a very high percentage of these accused males have been innocent of any crime and of any so-called sexual misconduct more serious than consensual drunken sex with a woman who later decided she regretted it. Even strong proof of innocence has sometimes been ignored by colleges in their eagerness to please their federal overseers and their campus activists. Indeed, in the name of encouraging women to report sex crimes, not to police, but to campus authorities, universities have created large incentives for young women either to claim that they did not give affirmative consent or to fabricate sexual assaults that never occurred. Why would a woman do that? I used to ask myself that. Now I've seen case after case in which the woman lodged an accusation either because of a simple regret or as an excuse for cheating on a boyfriend or to take revenge on a former boyfriend or to pursue the rewards of perceived victimhood. That may seem especially odd, but that's what Joe Biden's defenders plausibly suggest may have been a motive for Tara Reade recently to accuse him of sexual assault back in 1993. By the way, if a college kid today were accused of doing what Reade says Biden did, the kid would clearly be found guilty no matter what he said in defense and expelled, at least if the campus rules were as prescribed by Joe Biden. And in most campus cases I've seen, no conduct that would violate criminal law or even violate any reasonable definition of sexual harassment was even alleged, much less proved. This is not to deny that rape and lesser sexual assaults are serious problems on campuses, as they have been worldwide throughout human history. But contrary to current mythology, America's campuses may be among the safest places in the world for young women. They are, however, becoming very unsafe for falsely accused young men. How much has all this done to reduce the number of actual sexual assaults on campus? Nothing, it seems. At least, not according to Joe Biden. He unwittingly amended a couple of years ago that 6 years of Obama administration efforts did not reduce the number of campus rapes at all. He said instead, the percentage of college women victimized by sexual assault was the same today as in 1995. Now, in fact, the number of sexual assaults had plunged on campus between 1997 and 2011, according to the best Justice Department statistics, which also showed that young women on college campuses were in less danger of being victimized by sexual violence than young women who did not go to college. With that, I'll stop and let my colleagues talk. Thank you.
Thank you, Stuart. Jennifer, what are your thoughts?
Sure. Well, first of all, thanks, Kurt, for having me. And thank you also, Stuart, for your remarks. Before I begin, I really want to start off by saying, for those of you who haven't read Stuart's book, and I have it right here, he's probably too modest to talk about it, The Campus Rape Frenzy. It's really the seminal work on this topic. And it not only catalogs so many of the injustices that have occurred on campus, but explains, as he did briefly in his remarks, sort of how we got to this point. So really, if anyone is interested in how we got here, I encourage you to buy and to read Stuart's book with Casey Johnson. Anyway, I'd like to talk a little bit about some of the things the regulations don't do, and why people who generally applaud the efforts of Betsy DeVos to restore due process can't just claim victory and go home after last week. Before I do that, I'll just quickly review what's been in the press and what most people already know about the rules. The new regulations, which did go through the appropriate notice and comment period, unlike the past administration that just issued guidelines about this, they do attempt to restore the presumption of innocence, mainly by requiring that schools inform those who are accused that they do have that presumption of innocence in their favor. They also essentially eliminate the single investigator model, which was very problematic. That was where you basically had one person act as judge, jury, and executioner, so to speak. And so now students who are accused will have an opportunity to tell their side of the story in live hearings, and with rape shield protections in place, have an opportunity to question the claims that are made about them. So those are all really important protections, and I certainly applaud the Department of Education for making this effort to restore due process. But there are a couple of things that the regulations don't do, and I think people need to be aware of. The first is substantive. Well, the first one, I'm only going to talk about two, but the first one I'm going to talk about is substantive, and the other is procedural. Excuse me. The substantive issue has to do with what Stuart talked about in his remarks, and that is the ever-expanding definition of sexual assault used by college campuses. Most people, when they hear the term sexual assault, assume that we're talking about a rape or a sexual battery of some nature. Turns out, no, we're not. What many college students today refer to as sexual assault are not rapes as defined by the criminal law at all, but rather, as Stuart said, intoxicated sex that may very well have appeared consensual to an observer had one been present, but which after the fact, in the light of day, one of the parties is unsure about. So that is the vast majority of cases that these administrative tribunals deal with. And in fact, it turns out that foggy, ambiguous, intoxicated sex is in fact prohibited by most colleges and universities. Some, it's different at every college. Stuart's book catalogs a lot of the policies. Some prohibit any sex under the influence of alcohol at all. Some say that consent must be verbal and affirmative at every single stage of coupling. Something that probably never happens ever. But anyway, the new rules actually don't change any of that. What they do say is that schools will not be held liable for sex discrimination under Title IX unless they are deliberately indifferent to claims of sexual harassment. And that essentially codifies the standard that the Supreme Court articulated in Davis versus Monroe County, and reminds schools that Title IX doesn't prohibit certain student behaviors, rather it prohibits schools from treating males and females differently. So this is an important reminder from the Department of Education, but colleges remain free to have their own codes of conduct, to craft their student handbooks any way they'd like, and to prohibit behavior that doesn't legally rise to the level of sexual harassment. So, for example, many Christian colleges actually do prohibit and punish students for engaging in any premarital sex whatsoever. They're still allowed to do that. And non-religious colleges can continue to take less dramatic steps and define certain types of sex as non-consensual and therefore punish it. So, despite these new regulations, that is exactly what schools are going to do. In fact, there are materials out already from special interest groups urging students and alumni to write to their universities and to urge them to make sure that they continue to prohibit these behaviors even in light of the regulations, because technically they're allowed to do that. The problem is that when schools punish non-criminal behavior as sexual misconduct, they create the impression that these students are in fact criminals, when the vast majority of them are not. And that is particularly problematic when you consider another thing that the rules don't do, and that is prohibit colleges from using the preponderance of the evidence standard. What the rules do say about that is that colleges, if they're going to lower the burden of proof in cases of harassment and assault and use the preponderance of the evidence standard, then they need to use that standard across the board in all cases. So cases that involve professors, cases of academic integrity, cases involving vandalism, they need to be consistent. So while that's definitely an improvement in the sense that we want consistent disciplinary procedures, I still think that the preponderance of the evidence standard is too low. especially when we are talking about he said, she said cases involving alcohol and faulty memories. Because basically what schools are essentially saying when they adopt the preponderance of the evidence standard in such cases is that they are willing to find a student responsible for sexual assault if the victim is more likable and thus slightly more believable than the accused. And that isn't fair. Now, what colleges will say in their defense is that these aren't criminal cases. They're not finding students guilty. They're finding them responsible. And so, you know, they'll say that a higher standard isn't necessary. I would argue that, you know, maybe the obviously proof beyond a reasonable doubt standard isn't necessary, but that preponderance of the evidence is still too low, and that the appropriate standard really is and should remain clear and convincing evidence. It is true that we're not talking about taking away a person's liberty like we are in the criminal system, but you know, liberty isn't the only thing at issue. I mean, these cases involve serious lifelong consequences. Somebody who's kicked out of school and labeled as a rapist is going to have to deal with those consequences for the rest of his life. And so I would argue that the seriousness of the charges certainly warrants a higher standard of proof than preponderance of the evidence. So these new regulations don't really address that problem. They don't address the culture on campus where large swaths of conduct are considered to be sexual assaults, both by the university bureaucrats and by many students. And so I think we as parents, citizens, alumni, we need to remain vigilant in talking about this issue and educating people about this issue, even though these new rules are now in place. So with that, I think I'll leave it there and cede any remaining time to my colleagues to discuss where we go from here.
Thanks, Jennifer. Nicole, what are your thoughts on all this?
Sure. So yeah, I'm gonna just take a minute as a sidebar. Since I lead a free speech organization, I just want to emphasize again how significantly Title IX has impacted speech on campus. I think, you know, when people think about Title IX now, they think about rape. 10 years ago, they thought about sports. But I think it's really important to note that the prior administration really went hard after speech, genuine academic speech, alleging that speech created a hostile environment. A lot of people in this call have probably heard of Laura Kipnis, the feminist film professor from Northwestern University. She was investigated for criticizing university policies against professor-student relationships in the Chronicle of Higher Education. I mean, she wrote an op-ed. At Yale, a sexual misconduct committee investigated an undergraduate student for using rape as an example of an irrational act in a philosophy paper. And certainly there are countless examples of students who have been investigated for offensive jokes, among other speech that is very obviously protected by the First Amendment. So this is, I think, really important. For far too long, universities made a conscious decision to sacrifice the First Amendment on the altar of Title IX. These new rules clarify what must be investigated, when, and by whom, and they provide protections for constitutionally protected speech and expression. And I think the administration is to be lauded for that. So just to back it up a little bit, to put everything in context, you know, what happened prior to this? Previous lawsuits. Really, the only major lawsuit to date challenging the education department is a suit that was filed in the beginning of January 2018 in the Northern District of California by 3 organizations: Serve Justice, the Equal Rights Advocates, and the Victim Rights Law Center. And they were represented by groups called Democracy Forward, the National Center for Youth Law, and the National Women's Law Center. Plaintiffs sought declaratory and injunctive relief as well as attorney's fees. Obviously, if you're filing in the Northern District of California, you're kind of hoping for a nationwide injunction. And the judge, in case anybody's curious, was Magistrate Judge Jacqueline Scott Corley. The group's standing claims were based on the fact that the plaintiff organizations all work with alleged victims, and they now need to devote additional resources to comply with the interim guidance that people who they say are survivors don't understand the new rule, they're more scared to come forward, etc. Specifically, so that this is all challenging the education department's interim guidance from 2017. And the 3 causes of action listed were that the guidance violates the Administrative Procedures Act, it's ultra vires, and it violates the Equal Protection Guarantee in the 5th Amendment. So on the APA front, they say that by permitting mediation, which the Obama administration had totally vetoed, they say the interim guidance eliminated victim protections, and in so doing is a conclusive shift in department policy. On the ultra vires front, the policy shift is in excess of the Education Department's legal authority, and equal protection, it disproportionately impacts female students. So interestingly, the suit claimed that the Obama administration's 2011 Dear Colleague letter and 2014 question and answer document, which were both not issued via notice and comment, didn't actually reflect any policy changes, that they were rather clarifications consistent with its previously issued guidance. This is not true. So, you know, I know it's a bunch of lawyers on the call, so let's focus on the Administrative Procedures Act for a minute. Under the APA, a regulation can be struck down in court if it is arbitrary and capricious. That is an example if the agency acted contrary to the goals of the statute, if they failed to explain what they were doing, or they failed to consider important aspects of the issue. So the plaintiffs made a number of efforts on this front. They amended the complaint several times, adding in details about how the White House had ignored allegations about Rob Porter, that the White House supported Brett Kavanaugh, the fact that the DeVos family had donated to the Foundation for Individual Rights in Education and met with groups like Families Advocating for Campus Equality. So they're so biased, they can't, this is not a real rule. So just kind of looking through very quickly how this all played out in the courts. The government, unsurprisingly, filed a motion to dismiss. And in October 2018, the court actually granted the government's motion to dismiss on the grounds that there was no final agency action. But they invited the plaintiffs to revise their complaint. So this was not surprising. Courts really don't like it when you challenge a regulation before it's finalized, because obviously the agency can still change some of this stuff. And they generally don't let you challenge a guidance document unless it is so formal that it's essentially the same thing as a regulation. However, all these groups were granted associational standing to continue with their other 2 claims based on a chilling effect on reporting and observed decrease in student-filed complaints. So the plaintiffs filed an amended complaint, they dropped the APA claim, the government filed a motion to dismiss. Interestingly, in March 2019, the court reconsidered its earlier dismissal and allowed the APA claim to proceed because non-binding policies can have legal consequences and practical effects alone can render an agency action final. So in April 2019, they filed a 3rd amendment complaint, they revived the APA part. And then in November 2019, the courts found that the plaintiffs had Article 2 standing, but because there's not yet final agency action that produced legal consequences for noncompliance, it was tossed. So in a press release, the plaintiff said that, you know, the ruling doesn't address their actual claims about the guidance, it only focuses on the finality, but, you know, it considered it a victory because they said it affirms that organizations like ours have standing, and second, by dismissing the case on finality grounds, rather than reaching the merits of plaintiffs' claims, the court leaves the door open to mount such a challenge in the future when this administration issues its final rule on Title IX and sexual assault. So that takes us to this week. Now that the final rule has been issued, the challenges are coming. It's likely that the Serve Justice Coalition is going to revive their APA challenge. And I mean, they're going to throw in all the other stuff, that it's bad for women, it conflicts with Title IX's overriding purpose of preventing sex discrimination, et cetera. So, you know, what is the standard? The agency has to articulate a satisfactory explanation for its actions, including a rational connection between the facts found and the choice made. And agency action is considered arbitrary and capricious if the agency has relied on factors which Congress has not intended it to consider, failed to consider an important aspect of the problem, offered an explanation for its decision that runs counter to the evidence, or is so implausible that it could not be ascribed to a difference in view or the product of agency expertise. That being said, agencies are free to change their existing policies as long as they provide a reasoned explanation for the change. So how will this stand up? I mean, like, let's game this out. You know, the DC Circuit has been pretty good on this front. The court has basically understood its role to be confined to ensuring that the agency engaged in reasoned decision-making. And the substantive decision must be supported by substantial evidence in the administrative record. You know, so did this happen? Let's look at the regulations that were released last week on May 6th. There were actually over 2,000 pages of explanations that respond to the more than 120,000 comments that were received during the rulemaking period. So I think, it's my opinion, that the reasoned decision-making part is you know, that's probably going to be contested, but I think they've certainly met the substantial evidence and searching and careful inquiry burden. So, you know, that's being said, a lot of other groups besides the Serve Justice Coalition have all spoken out. We've seen a lot of press releases and statements from other groups like Know Your Nine, the National Women's Law Center, and the ACLU. They have all said that they're going to sue. I mean, this is going to result in a flurry of litigation. This is, as a side note, that's all separately. This is not going to be some massive joint thing. I think the ACLU's stated concerns with the new rules are kind of interesting. They say that by adopting a rule that subjects sexual harassment to different standards than other forms of harassment, the Trump administration is doing exactly what Title IX prohibits, discriminating on the basis of sex. So it's likely that what they're doing is they're saying that because under Title IX they're using severe and persuasive, as opposed to Title VII, which is severe or persuasive or persistent, that they have created two different standards. And, you know, is it true or is it false that using different standards for Title IX and Title VI would be discrimination on the basis of sex? Sorry, Title VI. Did I say Title VII? I meant Title VI. Discriminating against sex discrimination complainants is not the same thing as discriminating against sex, because sex discrimination complainants can be of either sex. And you know, agencies, frankly, should be able to move one step at a time. And it's not like in redoing Title IX, they could also loop in Title VI changes as well. And so, you know, that's something that if they were to do Title VI changes at the same time as Title IX, that probably would be swept in under, you know, exceeding their authority. So I think it makes sense for them to sequence this a little bit. Will we see this administration move forward on Title VI changes? Frankly, probably not. But that being said, I've kind of rambled on a little bit. Other groups to keep an eye on besides Know Your Nine, National Women's Law Center. In August 2018, 6 additional organizations all filed a motion for leave to intervene as plaintiffs in the Serve Justice lawsuit. Those are Women and Children's Advocacy Project, Equal Means Equal, National Coalition Against Violent Athletes, Allies Reaching for Equality, Women Matter, and We Are Women. So those are groups that all might end up intervening or filing their own lawsuits at some point in the future. I think there, frankly, there's going to be no shortage of lawsuits, and you know, it remains to be seen. Certainly, this administration, this Department of Justice, will stand up and defend these rules. But you know, what happens in November, I think, is going to have a lot of bearing as to how vigorously this plays out in the future. So, with that being said, as the non-lawyer, I turn it back over to you.
Thank you, Nicole. And before I turn to questions, I just wanted to mention to the audience that we'll be doing another one of these and instead of on Thursday at 12:30 p.m., not on Title IX, but, you know, a few years ago I would have said the less controversial topic of antitrust. But these days, with everyone wanting to break up the tech companies, I'm not sure that it is less controversial. But anyway, that'll be in 3 days. And a bunch of questions come to my mind while you all were talking. But before I get to those, let me mention a question that we have from the audience, who pointed out that there's a leading Title IX group that publishes a lot of the training materials, and they say, wait a second, even though the new regs require them to be put on a university's website, these are copyrighted materials. You know, we only make these available for, you know, private viewing. We're not going to let them be put on a website. Does that, what does that tell you about how public these training guidelines are really going to be? And I'll start with Stuart on that since he talked about it, but Nicole and Jennifer can weigh in as well.
Well, you know, there will be a clear conflict between what the rule requires, which is not ambiguous. They must be on the website. If there is one, they must be public, and the claimed intellectual property rights. I'm a little skeptical of the intellectual property rights being a genuine claim, as opposed to, hey, we like them secret because we don't want anybody to know what they say. But it's not totally frivolous, and I suppose some court will have to sort that out. I'm not quite sure how it would sort out. And
I suppose, well, go ahead. I'm sorry, I interrupted.
Well, it's the perfect example of how schools and their allies on this are going to do everything they can to get around these regulations and to keep doing what they're doing. And you know, a lot of blame is often put on the Obama administration for the guidance, the 2011 Dear Colleague letter, but the reality is that that guidance was welcomed by the colleges, to say the least, because it gave them political cover for exactly what they wanted to do anyway, because there was already this big cultural push by student groups and activists to go in this direction.
I'm curious, looking at the forum shopping that the plaintiffs did in the 2018 case. I mean, you could also conversely kind of forum shop something about getting access to some of these documents. If you were to bring something in Texas, let's say, for a group that has worked with a TICSA on this, I don't know if our side plays the forum shopping game as well as we should. And so that's something that, if you don't want these documents to be released, I don't know if you're going to be able to get away with that for a long time.
Well, speaking of forum shopping, are any of you worried that even though it sounds to me that the claims of the groups, the Administrative Procedures Act claims to these regs or challenges to these regs are pretty weak, are you worried that these days during the Trump administration, it seems like all you need to do is file suit somewhere in the Ninth Circuit and you'll find a liberal district court judge who's more than happy to enjoin anything that the Trump administration does. So are you all worried that, these regs are not going to survive?
I am concerned about that, but in a way, I'm hoping that happens, because that would be a wonderful way to drive it toward the Supreme Court. And I think the Supreme Court would give the right answer to these questions by and large. And I think actually it'll be interesting to see the strategy of the people who want to kill these rules, because I don't think they want to be in the Supreme Court. Also, the likeliest way to kill these rules is if Biden wins the presidential election, Trump loses, and then they'll turn him around as fast as they can. Speaking as someone who doesn't like Trump or Biden, I have mixed feelings about that. But if I were an opponent of the rules, my best hope for getting rid of them would be a Biden win in the election.
Any other thoughts on that?
I mean, I love the overreach. I love the fact that they're going for the nationwide injunction. I'm waiting for Ken Paxton to ride in on a white horse and just, raise bloody hell about these nationwide injunctions, because, it's not reasonable and people are sick of it.
Now, speaking of the courts, I know some of the critics of these regs say, due process, that's great in court, but this isn't a court. Why are these students entitled to due process?
Well, first of all, if they go to a state school, they are absolutely entitled to due process and everything that means. Second of all, if they go to a private school, a lot of private schools are governed by state law that requires good faith and fair dealing or some other, procedural fairness. And so courts that have looked at this have found that students are entitled to these rights. So really what the Department of Education is saying is no different than what many courts that have looked at these cases have already found.
And sort of I don't know if it's the flip side of that question, but a lot of people would say, why are schools even involved in this? Sexual harassment can be dealt with through a civil suit in actual courts. Sexual assault can be dealt with through criminal charges. I mean, especially in the case of sexual assault, shouldn't the student who thinks they've been assaulted go to the police? I mean, our schools, why are schools become substitutes for the court system, which is set up precisely to deal with these issues while protecting the rights of both sides?
I'd like to just say I think the schools should not set themselves up as alternatives to the court system. They can have disciplinary rules, I think, for good behavior that's short of criminal behavior. But the real reason that they've jumped into this and that the activists want them jumping into this is that they think the criminal courts are not likely enough to find in favor of every complainant, and they think the campuses will be far more friendly to them. The hard fact, though, is under most of our legal rules, if the campuses want to do something unjust and stupid, they can do it unless there's some clear right that's being violated. And I think here we do have clear rights being violated, and the rules point to some of them. And one of them, which we haven't really touched on too much lately, is I think the way these rules are administered and the way they're written amounts to systematic discrimination against male accused students. There's a school of thought that, oh no, it's only discriminating against accused students, and they're not all male. But they're almost all male, and what's driving it is rather clearly anti-male animus.
I do think there's another piece of this, and I say this, not so much as a lawyer, but as a mother of 2 daughters who are at college right now. I do think there's a sense among college students who might genuinely feel that they were wronged, that they don't want to bring a criminal case because they don't believe they've been victims of crimes, but they do want the boy to understand that he was a jerk or that his behavior was inappropriate. And so they go to the Title IX office, and in many cases, the Title IX officers lead them to believe that nobody's going to get kicked out of school. We are going to counsel him. And please write down your story. And we'll take care of this, and we'll make sure he understands that he can't behave this way towards women. And so, you ask why people are bringing their claims to the Title IX office. I think students have been sold a bill of goods that somehow the school can fix interpersonal relationships. And I don't think that some of those young women are ill-intentioned. I mean, we did talk about, there are some cases where young women want revenge on someone who broke up with them. But there are a lot more cases where these young women just feel hurt and want the person to know that they caused them great pain. And so that's a large part of it. And we need to address that culturally by talking to our daughters and students and telling them, explaining to them that the school isn't the proper vehicle for addressing this.
Interesting that there are so many. I think it's interesting that looking at some of the people who have really been pushing these rules, like I think of Kristen Gillibrand, who was so outspoken in removing military issues from military tribunals, saying that they're biased, they can't properly adjudicate an assault case, up to 2 members in the military. Yet, and the military actually is professional, and there are JAGs, and there are lawyers who actually have gone through proper procedures. And now you have those same people wanting to devolve authority away from the proper criminal justice system or the civil court system to Title IX administrators who have very little training, and what training they do have is super, super biased. This trauma-informed victim mentality, neuro nonsense. That's really concerning. So I think that's kind of just a fascinating sidebar.
Can you tell us a little more about this trauma-informed theory and, why it does, if I understand it correctly, it basically, it amounts to, even if the woman's story is not consistent, that she's still telling the truth.
I mean, Stuart, this is like you have a chapter on this.
Yes. Well, the neuro, whatever it is, right, neuropsychological part of it, is a theory that Emily Yaffe, a great journalist, completely debunked in The Atlantic a couple of years ago. A theory that something about sexual assault scrambles one's brain to the point that none of the thoughts you have after that happens are consistent with ordinary human experience. Though, therefore, if the woman says the opposite today of what she said yesterday happened, or if she did friendly things with the so-called rapist after he supposedly raped her, and did contradicted herself, told inconsistent stories, had a demeanor that seemed unconvincing, all the usual signs of lack of credibility, cannot be deemed to be signs of lack of credibility in these sexual assault cases or sexual harassment cases, and that they all seem to militate in favor of the guilt of the man. It's a way, these theories, these trauma-informed theories, are a way of saying, no matter what the evidence seems to show, the man is guilty.
Well, we keep talking about the man is guilty and the woman is the accuser, but Jennifer mentioned that a lot of schools say it's an offense to have sex when you're intoxicated. And I'm guessing in most of these cases the woman and man are both intoxicated. So how does the school figure out which one is the victim if they're both intoxicated, or do they just assume that the woman is the victim? Or am I wrong?
What it does, Kurt, is it creates a first to file, first to the courthouse system, right? So there's a famous case out of Amherst College where both parties were intoxicated, and the woman performed oral sex on the male student. He says he passed out. He passed out. He has no recollection. I mean, who's the victim here? But she went and filed with the Title IX office, and they threw him out. And he did sue Amherst College, and ultimately Amherst College settled that case with him for an undisclosed sum. But yeah, so it sets up an incentive where, I think the first to file is the victim, which is usually the woman.
Nicole, I think you wanted to say something.
No, I think that's a great point. Robbie Suave has done a lot of reporting over at Reason Magazine on this as well. I think there was something at Ohio State within the past couple of years as well. So it's kind of an appalling, perverse incentive that has been set up.
Now, Jennifer, I think you have a son as well, as you mentioned, two daughters in college. You have a son as well, right?
2 daughters in college and a son and a daughter in high school.
Okay, wow, big family there. Now, would you, I guess I'll ask you a question about both your daughters and sons. Would you advise your son, given this atmosphere, that if there is, drunken sex, would you tell your son, if it looks like there's going to be a problem, you should be the first to file?
I would tell my son not to have drunken sex. Start with that.
That's probably the best advice. Or and then as for your daughters, I know that that these rules are not just about due process for men, that they also provide additional protection for your daughters and women generally. Can you tell us, about that?
Well, the rules do provide protections for complainants in the sense that they strongly encourage supportive measures by the university, whether it's counseling or no contact orders or course schedule changes. All of that is true. But if you're asking me what I would tell my daughters, I would tell them that if you are harassed or raped or sexually assaulted in college, call me, call another trusted adult, call the police. Do not put your hands first and foremost, put yourself first and foremost in the hands of a university that cares mostly about protecting its own interests than in protecting yours. I mean, I would advise any student of that. That doesn't mean you won't have to go to the university and, request a no contact order. I know plenty of people who were assaulted back in my day who simply went to the university and asked that, the person that they be able to not be in the same class as the person or switch dorms so they didn't have to come in contact with the person during the pendency of criminal trials, and the university turned a blind eye and said no. So, there are occasions when you're going to have to ask the university for help, and hopefully these rules will encourage them to provide those supportive measures. But I would not encourage anyone to think they were going to get justice from a university.
Kurt, I'd like to add 2 points on why I think
Sure.
these rules are good for victims, actually, although most of the talk is how they're more fair to accused students. One, lots of women, as I think was pointed out earlier, begin this process with no intention of having a great big proceeding where the guy gets kicked out or anything out. They may, they may want something, but they don't want that. And they tend to get misled and dragged into it becoming a huge deal where somebody gets expelled, the guy gets expelled by the university bureaucrats and their system. Yale is particularly guilty of doing this, but a lot of campuses are guilty of doing it. The other reason I think it's going to be more and more a good thing for real victims is the system now that the university use has no credibility whatsoever among reasonable people anywhere. And therefore, a woman who is proclaimed a victim by a university will be met with skepticism by a lot of observers, even if she really is a victim. If you have a system that's respected for having integrity, then your victimhood is recognized more widely and easily.
That's a good point. I think I detect that none of you are very hopeful that these regulations are going to change things on the ground. I mean, what I hear from you, and tell me if I'm wrong, is that you think that these schools really have their own agenda here that isn't even necessarily meant to protect women so much as to protect themselves and seem politically correct. Am I being overly pessimistic in saying that you all don't seem very optimistic going forward?
Well, I am pessimistic about the culture and the larger issues on campus, but I will say, I heard from Samantha Harris at FIRE this morning, and she really strongly believes that even the slightest changes and shift in these rules and in providing due process can make a big difference in the lives of her clients and individuals. And to the extent that that's true, I applaud these regulations, and I certainly think they were worth doing. I just think we need to continue to be vigilant, that's all.
Also, I'd say a young man who's railroaded unfairly by the colleges in spite of these rules, in violation of these rules, will now have an even better hook to take his case to court and to the university than he has now. Lots of them have done this already. Lots of them have won. But I think the legal case by any wrongly accused, wrongly, procedurally disadvantaged accused student are going to be a lot stronger. The court option is going to be a lot stronger, and the college campuses are going to, if they lose enough cases in court or they see enough losses in court coming, they might actually have to change their approach.
And Nicole, since you're with Speech First, how hopeful are you that these new rules are going to help encourage free speech on campuses?
Yeah, I mean, I think they staked out some good ground in really making sure that constitutionally protected speech is protected, that it's not looped in. Really going back to Davis, I think is important. Severe and persuasive and objectively offensive is good. So I think that's important. The fact that there was so much overreach before that we're trying to claw back space. I mean, I could pull my libertarian card. There shouldn't be a Department of Education at all, but it's here. These regulations are here, and so how can we make this? How can we roll it back and make it much more narrowly tailored so it's better and doesn't infringe on as many people's rights? And so, I mean, even as Jennifer was saying, moving away from the single investigator who was somebody who had an axe to grind and had numbers to hit, to go away from that to allowing these the cross-examination, with, as she mentioned, with the rape shield, where it's not students directly cross-examining each other. It's a representative from them. Every little bit of additional due process helps. And as Stuart said, it helps to restore trust in the system. I think so many people just don't trust the system anymore. If I got somebody in trouble and under a system called a kangaroo court, I mean, how valid does that sound? If I was actually assaulted, I brought something under a kangaroo court, and then he went to court and then had it overturned because of due process violations, that's traumatic for me as someone who has gone through a horrific experience. And so if there are clear procedures across the board for everyone, I think it makes everybody better off.
Now, again, I guess I should point out that even if those on this panel, think we'll have marginal change, people on the left seem to think that this is Armageddon and there'll be enormous change. I mean, some of it may just be rhetoric. I think my favorite example of overreaction was Catherine Lamon, who used to head the very division at the Department of Education, the Civil Rights Office that's responsible for these regs. She said the new regulations are going to take us back to the old days when it was possible to rape and harass students with impunity. So just to be fair, the other side thinks this is going to make a big difference. But again, let me add to that.
I'm sorry, Kurt, let me add to that. I would ask any reasonable person who's wondering about these hyperbolic attacks on the rules to just read them. You don't have to read all 200 and some pages or 2,000 and some pages. Just read the rules. You know, there's a lot of stuff in
30
there.
pages, yeah.
Read the rules themselves. And what's the problem here? They look like, you know, the ACLU might have written them 20 or 30 years ago. They're very reasonable, protect the rights of accusers and accused alike, stop discriminating against one side or the other. And it's very hard when you read them to identify anything that a reasonable person would be alarmed by.
The presumption of innocence, how dare you?
Pardon?
I think that's absolutely right. I mean, I think that this should not be a partisan issue. It shouldn't be. And actually what you've seen in terms of the people on quote unquote our side, the side of due process, is a coalition of Republicans, Democrats, civil libertarians, conservatives. It's actually not partisan. It's the other side that's very, very far left who's opposing these reforms, because this is common sense. This is fairness. This is, you know, due process is as American as apple pie. Nobody should be against this.
Now, of course, in many contexts, it's the people on the left who most push for due process. They want due process for enemy combatants and people who are in the country illegally, et cetera. So again, the idea of due process is not a conservative idea. Speaking of politics, I guess the elephant in the room that we've only briefly mentioned is Joe Biden's stance on all this. He's been very critical of the new regs. And as I pointed out in an op-ed I had at Fox on Friday, that contradicts what, their criticism of these regs contradicts what seems to be their new standard in the wake of Tara Reade's allegations, which is that while women need to be listened to, they shouldn't be automatically, they should certainly not be automatically believed, and there needs to be due process. Now, that is a new standard coming from the left. You know, it was the opposite during Kavanaugh. So, I mean, to me, it seems like hypocrisy. Am I missing something? Is there more to it, or is this just, you know, politics and hypocrisy?
You're not missing anything.
I think in the case of Biden and his defenders, it's flagrant hypocrisy. It's obvious hypocrisy. It's impossible to see it as anything other than a hypocrisy unless you just can't bear to see Trump win. Now, I am one of those who can't bear to see Trump win, but I can't bear to see Biden win either because of all the hypocrisy. And so I'm sort of between a rock and a hard place.
The question is, Stuart, can you bear to see Betsy DeVos replaced by Catherine Lemon? That's the real question.
That would be an occasion for signing up for, who's that guy who's trying to send somebody to Mars? I might jump on that ship.
I appreciate the people like Lisa Bloom who have said, you know what, I believe Tara Reade, but I hate Trump so much. I mean, at least you're being honest. So, you know, I encourage more people to do that.
Well, you know, it'll be interesting to see. Certainly, Tara Reade's accusations will be part of the campaign, and I wonder if these Title IX regs are going to be, you know, the Dems are going to be trying very hard to you know, get women not to vote for Trump, and I wonder if they're going to bring up these Title IX regs. We will see. We only got a minute or two, but any closing thoughts from any of our three panelists?
Just one from me. I said earlier that Biden would be found guilty by any college tribunal of what Tara Reade says. I think if these rules are adopted, the same facts and complied with, I think Biden would probably be found innocent. I don't believe by a preponderance of evidence that he sexually assaulted Tara Reade. I'm not sure, but I'm not convinced. And so everyone who wants innocent people to be, you know, have the benefit of the doubt might take that position.
Yeah, I don't know by a preponderance standard, which is 50-50, but that's an argument for, you know, for why, you know, you want a higher standard. And these rules do allow schools to have a higher, clear and convincing standard, which is, you know, somewhat above 50% certainty that the accused is guilty. It's not a beyond a reasonable doubt that you have in court. But again, you know, perhaps some schools will raise the standard now that the Obama guidance has been replaced. We've run out of time. Somebody in our audience just said, "Great job by all the panelists," and I certainly agree. Thank you all for coming to our virtual panel today, and I know I've learned a lot listening to these three experts on Title IX, and I suspect we'll all be hearing a lot more in the coming weeks as these rules are debated. So thank you to the panelists, and thank you to the audience.
Thanks, everyone.
Thank you. Thank you all.